regarding an ADA discrimination claim. There are two issues: whether interacting with others is a major life activity, and whether the plaintiff, Eve Lambert, was substantially limited in her ability to interact with others. And the group of 200 LRW students got narrowed down to 32 students in the quarterfinal rounds, which took place on Friday. And then got further narrowed to 8 students on Saturday, then 4, and then our 2 finalists. Our 2 Golden Gavel winners. For the plaintiff is Spencer Wampole, and for the defendant is Harrison Brandt. All of the participants, everyone did a phenomenal job, and the finalists were tremendous, and all of the judges had great things to say about all the participants. So we appreciate most of these folks are 1L LRW students, so thank you and congratulations for your participation. I'm going to turn it over to John Bishop, who is the president of the Moot Court Board, and he will introduce our esteemed judges for the day's competition.
All rise. Oh yay, oh yay, oh yay. All persons having business before this, the Honorable Federal District Court for the state of Georgia, are admonished to draw near and give their attention, for the court is now seated. Justices Thompson, Hurlbut, and Chief Justice Aronson presiding. God save the United States. God save the state of Georgia. God save this honorable court. You may be seated. Before we begin the case, I'd like to read a short bio on your 3 justices. First, Judge David Thompson. Judge Thompson is currently the assisting presiding judge of the Orange County Superior Court. He was appointed to the bench by Governor Pete Wilson in 1997. Before Judge Thompson took the bench, he was an attorney with Morrison and Forster in Irvine and Rattan Tucker in Costa Mesa. In practice, Judge Thompson handles general civil litigation, was involved in all aspects of acquisitions, sales and development of real property, and also handled numerous writs and appeals. Judge Thompson received his bachelor's degree from Georgetown University and his JD, his Juris Doctorate, from UCLA. John Hurlbut is a senior partner at Rattan Tucker and a member of the firm's financial practices group. He's been practicing business litigation in Orange County since graduating from Stanford Law School in 1964. His practice emphasizes real estate, corporate, partnership, commercial, and business tort litigation. He's also been heavily involved in civic and charitable activities in Orange County for decades, including currently serving as the president of the Orange County Bar Foundation, and in the past serving as the director and president of the Orange County Youth Sports Foundation, and the president of the Tustin Boys and Girls Club. He's also received the Orange County Bar Association Harmon G. Scoville Award for the attorney who exemplifies the highest standards of the legal profession and who significantly contributed to the Orange County Bar Association. Chief Justice Aronson is an Associate Justice on the California Court of Appeals, 4th Appellate District, Division 3. He was appointed to the bench by Governor Gray Davis and confirmed to the court in 2001. Prior to his service on the appellate court, he served as a California Superior Court judge for 4 years, and his prior legal experience includes serving as a deputy DA for San Bernardino County, as an Orange County public defender, and a senior staff attorney at the Court of Appeals. He's also been an instructor in various legal studies programs and has been involved in several civic and charitable activities, including the Cystic Fibrosis Foundation, the Orangewood Home for Children, and the Victim Assistance Program. He received his bachelor's degree and his JD from the University of San Diego. He also has a Master of Laws degree from the University of Virginia. Justice Aronson, the court is yours.
Thank you. Welcome. We're going to call the case of Lambert versus the Atlanta Culinary Journal. And with that, then we're ready to proceed. Is the plaintiff ready? Sir, all right. Approach the podium.
Your Honor, before I begin, I'd like to reserve 3 minutes for rebuttal.
Okay.
Mr. Chief Justice, and may it please the court, my name is Spencer Wampole, and I represent the petitioner in this case, Ms. Eve Lambert. I will be addressing the issues of whether Ms. Lambert's acute mental impairments substantially limit her ability to interact with others. Your Honors, this case is about upholding the purpose of the ADA and fulfilling Congress's clear intent to protect vulnerable individuals like Ms. Lambert. We respectfully move this court to find that Ms. Lambert is disabled under the ADA for the following 2 reasons. First, because interacting with others is a major life activity consistent with Congress's clear intent that is expressly recognized by the EEOC and is an objective and workable standard. And second, because Ms. Lambert's acute mental impairments substantially limit her ability to interact broad interpretation to reinstate a broad scope of protection for mentally impaired individuals like Ms. Lambert. Congress rejected the overly narrow approach by the Supreme Court in Toyota Motors v. Williams, which held that major life activities were activities that are of central importance to most people's daily lives.
Counsel, where do you find language in the Act itself as amended that supports the idea that interacting with others is in fact a major life activity? Let's talk about the language to start with.
Your Honor, I point you to Section 42 U.S.C. 12102, Section 1A, which expressly provides the list of major life activities is non-exhaustive. Congress provided this non-exhaustive and broad categorical definition to ensure a flexible standard for courts and the EEOC to interpret. Accordingly, even before the amendments, the Ninth Circuit in McAllen v. County of San Diego found that interacting with others is an essential and necessary function of daily human life. Importantly, in the Amendments Act, Congress granted the EEOC the express authority to interpret the language of the statute to be consistent with their broad intent. Accordingly, the EEOC's regulations now expressly identify interacting with others as a major life activity.
The statute itself, though, doesn't list as an example interacting with others, right?
No, Your Honor.
Well, there was a split in the circuits when Congress amended the statute, right?
Yes, Your Honor.
Okay, now, the failure of Congress to resolve that split, what's the significance of that?
Importantly, Congress included the activity of communicating, which broadly encompasses interacting with others. However, interacting with others and communicating are not synonymous. Communicating involves the transmission of information through a variety of mediums, but by definition does not require physical, face-to-face human interaction. Interacting with others is the ability to connect with others in a face-to-face exchange. While Ms. Lambert demonstrated a limited ability to communicate with others over the internet, she was completely unable to interact with other people in a face-to-face environment, or even over the phone. Defense counsel may contend that interacting with others and communicating are synonymous. However, if this were true, an individual who demonstrated a limited ability to communicate, but a complete inability to interact with others, would be barred from recovering under the statute. This would be clearly inconsistent with Congress's intent.
To follow up on Justice Aronsen's question, why can't we infer when the new statute was enacted that it didn't include communicating, or interacting with others? Why can't we conclude that whereas they wanted to reject Sutton and wanted to reject Toyota, he didn't speak to the issue even though there was a split in the circuits? Why can't we conclude that Congress intended to specifically exclude interacting with others as a major life activity?
Your Honor, Congress provided this non-exhaustive list with general categories of activities that are major life activities. Interacting with others, as I said previously, is a narrower standard that fits within the category of communicating. And importantly, this court should look to Congress's clearly expressed intent to broaden the scope of protection for mentally impaired individuals. Moreover, as you referred to getting along with others, the Second Circuit in Jacques v. DiMarzio has clearly distinguished interacting with others from the vague and amorphous standard of getting along with others. While getting along with others requires the courts to look to the subjective relationships of the parties, interacting with others has objective and quantifiable measures of an individual's ability to interact with other people in a face-to-face environment. By recognizing an objective standard like interacting with others, this court will not be increasing the amount of litigation because a plaintiff must still prove the substantial limitation requirement under the statute.
But is interacting with others, doesn't that involve two people, and doesn't that then lead to some vagueness that makes it difficult, a lack of certainty for businesses that are operating in this arena?
No, Your Honor. As clearly indicated by the Ninth Circuit, interacting with others is no more vague than caring for oneself, which is an enumerated activity in the statute. This court should recognize interacting with others because it is an objective and necessary standard. Courts have gone so far as to say that interacting with others is an inherent part of what it means to be human. So to fulfill Congress's this court should find that interacting with others is a major life activity.
Isn't caring for oneself just as vague as interacting with oneself, or interacting with others?
Yes, Your Honor. I believe that interacting with others is actually less vague than caring for oneself, which is enumerated in the ADA.
Well, no, you just told us that it wasn't vague because caring for oneself was also listed in the statute. So you've decided, or you're telling us that one section or one portion of the statute isn't vague by citing another portion that's just as vague. That isn't very satisfying.
Your Honors, interacting with others is the ability to connect with other people in a physical face-to-face exchange. While this is an objective standard that courts should look to that individual's ability to do that act. And by referencing caring for oneself, I'm merely indicating that it is, the recognized major life activities are not completely concrete, as in seeing or hearing. However, even these themselves have a threshold requirement. They require courts to set the objective standard. And looking at case precedent, as in the Ninth Circuit and the Second Circuit, interacting with others is an essential and necessary function of daily human life, just like walking or breathing. Courts have adopted interacting with others as a major life activity because it is an objective standard that is measurable. And moreover, that this will not increase the amount of litigation because, as I said, a plaintiff must still meet the substantial limitation requirement. Your Honors, this brings me to my next point. Ms. Lambert's acute mental impairments substantially limit her ability to interact with others as compared to most people in the general population. The most people test is laid out by the EEOC in its proposed regulations to fulfill Congress's clear intent to broaden the scope of protection.
What if those proposed regulations never get adopted?
Well, Congress has explicitly rejected the previous standard, which looked to the condition, manner, and duration of a plaintiff's impairment in a fact-intensive analysis. Therefore, those standards would not be appropriate under the current law. However, looking at Congress's clearly expressed intent in the plain language of the statute, this court should find that Ms. Lambert is substantially limited in her ability to interact with others as compared to most people in the general population. Defense counsel may contend that Ms. Lambert was able to order a coffee at Starbucks and was able to order her necessary prescription medications. But, Your Honors, I point you to Section 42 USC 12102, Section 4D, which expressly states that an impairment that is in remission is a disability if the plaintiff is substantially limited in a major life activity when that impairment is active. Moreover, in the ADA Amendments Act, Congress directed that this determination is to be made without regard to the ameliorative effects of mitigating measures such as medication. However, even while on medication, Ms. Lambert's symptoms reached levels of paranoid proportions. Her symptoms were uncontrollable by the medications and by the various and intensive techniques that Dr. Haas has prescribed for her since through her vigorous therapy. Because Ms. Lambert's condition began at such a young age, when she was only 11 years old, Dr. Haas clearly states in his deposition that she was never able to learn the emotional skills necessary to interact with other people.
But doesn't she interact with other folks online, email, and even in person with her mother? It's not impaired or restricted in any way?
No, Your Honor. Ms. Lambert communicates with others online. And in fact, regarding her OCD support group, as she clearly states in her deposition, she's only a member of the OCD support group because they know what it's like to have the effects of such a debilitating condition. While Ms. Lambert does interact with her mother, she secludes herself from the rest of her family, including her aunt, who is her only family living nearby. Your Honors?
I want to follow up on a question from Judge Thompson, and that is the standard. You are assuming that we're going to adopt the standard of regulations that haven't been enacted yet. And I don't know how we can do that from a power perspective as a court. Let's assume that we're going to go to the old standard. And I want you to tell us how you think she complies with the Jake's test, which would be the harder of the two compared to McClellan, if that's the right terminology. Anyway, convince us that she complies with the Jake's test.
Your Honor, in Jacques v. DiMarzio and in McAllen v. County of San Diego, they both found that a plaintiff who demonstrates patterns of withdrawal, extreme isolation, and a failure to communicate when necessary is sufficient to find a plaintiff substantially limited in their ability to interact with others as compared to the average person in the general population. Congress expressly rejected this standard in the ADA Amendments Act, but assuming that this court were to adopt the previous standard, Ms. Lambert would still meet the limitation requirement. Because Ms. Lambert's condition began at such a young age, and she was never able to learn the skills necessary to interact with other people, she's continuously isolated herself from society.
Let me ask you about that, because in order to meet the standard, you have to show that she's significantly restricted in a major life activity. My understanding is that she goes to Starbucks regularly, routinely, to get coffee, and then sits at a particular table and works there for an hour on her computer. Now, as she's sitting in this table, I can only imagine she's just surrounded by germs and bacteria. Yet she continues to work on her computer unaffected by that. Now, how do you square that with the other complaints that she's raised about concerning her condition?
Your Honor, the record clearly indicates that Ms. Lambert separated herself and sat at an isolated table when she was at Starbucks. This court should make the determination of Ms. Lambert's level of limitation when her symptoms are in the acute phases and currently. While previously she was able to go to Starbucks, under the facts here, when Ms. Rain came into the Atlanta Culinary Journal and rearranged the desks into the center of the room and forced Ms. Lambert to attend staff meetings, Ms. Lambert's symptoms reached levels of paranoid proportion. In fact, she felt like she was going to die when she was in face-to-face interaction with her coworkers. She attempted to comply with Ms. Rain's request, but she felt like hives were strangling her neck. Her face turned beet red, and she couldn't speak because she felt as though she was suffocating. Ms. Lambert and Dr. Haas attempted to request isolated accommodations for Ms. Rain. However, Ms. Rain denied these requests. Subsequently, Ms. Lambert was unable to even leave her desk and couldn't function as an employee or even in the normal way that she could have before because she was forced to interact with other people. Your Honors, the nature and severity of Ms. Lambert's limitation not only substantially limit her ability to interact with others, but significantly and severely restrict her ability to interact with others under both tests, the most people and the average person test.
How does this case compare to the Rohan and, I guess it's Soilo case on the facts? How would you compare your client's impairment to the impairments involved in those cases? One was a family incest survivor and the other one had chronic depressive disorder.
Your Honor, I see my time is up. May I briefly answer your question?
Yes, go ahead.
Thank you. The plaintiffs in Rohan and Swallow both did not suffer from the acute nature of their limit, both did not suffer from such acute mental impairments as Ms. Lambert did that substantially limited their ability to interact with others. As I said, Ms. Lambert suffered a complete inability to communicate at times of stress. This is not true in the precedent cases. In fact, when she felt like hives were strangling her neck, she couldn't even function as an employee or as a person, unlike these plaintiffs in the other two cases. Thank you.
All right, thank you, counsel. We'll go to the defendant now.
Mr. Chief Justice, and may it please the court, my name is Harrison Brown, and I represent the defendant, the Atlanta Culinary Journal. Today I will be addressing how interacting with others is not a major life activity within the purview of the Americans with Disabilities Amendment Act, and moreover, how the plaintiff, Ms. Lambert, is not substantially limited in her ability to interact with others. This case is about a talented worker who is improperly trying to shift the blame of her termination away from a failure to cope with changes in her workplace. We respectfully request that this court find that Ms. Lambert is not substantially limited in her ability to interact with others, and before that interacting with others is not a major life activity, for the following two reasons. First, Congress set forth an extensive list of 18 major life activities and failed to include interacting with others. We may infer.
What do you make of the language that says included but not limited to. What does that mean?
Your Honor, as the plaintiff counsel pointed out, the findings of the Amendments Act prescribes a broad range of coverage. However, we may infer that Congress did not intend the statute to be too broad so as to do away with all meaningful limits. Now, as you yourself...
Wait a minute. The statute itself, the amendment says that the construction of the statute is, we are to get a broad construction. Now, how do you square that by saying it shouldn't be too broad?
Your Honor, ultimately, it's not the courts who have to decide whether or not someone is substantially limited in a major life activity, but employers. Now, as the Swallow Court points out, the Amendments Act is distinguished from all other sorts of civil rights litigation in that it imposes an affirmative duty on employers to make reasonable accommodations for disabled employees. Now, employers cannot comply to a standard that they do not understand, be it because it's vague or too ambiguous. And I believe that interacting with others is too ambiguous. Plaintiff's counsel himself kept saying that interacting with others should be considered a major life activity, but never once said what interacting with others actually means. We can infer that Congress was aware of this. As you yourselves pointed out, there was a split in the circuits on whether or not interacting with others is a major life activity. However, there was also a split in the circuits as to whether mending, another major life activity, should be included in the Amendments Act. The Parkinson Court in the Fourth Circuit questioned whether or not bending was a major life activity. However, the Whitfield Court in the Third Circuit said that bending is a major life activity. Now, aware of the circuit split, bending made it into the Amendments Act as a major life activity. However, interacting with others did not. There must be something about interacting with others that Congress wanted to avoid putting it in the statute for. We may infer that it's because it is a vague, ambiguous standard that employers will not know how to conform themselves to.
Why shouldn't we look in these pending regs, the EEOC's interpretation as expressed in the pending regs, and the compliance manual that has always included interacting with others? Why shouldn't we look at those guidance?
To your first question on whether we should look to the EEOC pending regs, Congress gave the EEOC authority to define the scope of substantial limitation. It, however, did not give it the authority to tinker with what constitutes a major life activity. And as for whether or not, even if it were passed, if we should include it, the EEOC may be said to overstep its authority granted to it by Congress under the Chevron 1984 Supreme Court test, where a regulatory agency such as the EEOC misunderstands congressional intent behind a statute, the court should not grant any deference to the regulatory agency's findings. Here, because the EEOC did not necessarily comply with congressional intent to not impose a indeterminate standard on employers.
The intent is unclear. The compliance manual has listed interacting with others as a major life activity. The statute's been amended to compel courts to give a broad construction to the statute. The post-amendment, the post-2008 amendments, the EEOC proposes to promulgate include a very liberal definition of the issue we're talking about. And yet, despite all that, you're arguing that we should ignore that and adopt and stay with the older, antiquated definition.
Yes, Your Honor.
How do we do that in light of the command that we broadly construe this statute?
Yes, Your Honor. To your point about the EEOC compliance manual, it's significant to note that the 2002 compliance manual included interacting with others. However, Congress, 6 years later, did not include interacting with others in the Amendments Act. Now, it's hard to believe that this is just a mere coincidence. The Amendments Act was 10 years in the making, and Congress debated this ad nauseum. It's highly unlikely that they simply left it out unintentionally. Moreover, as mentioned before, Congress only gave the EEOC to determine the scope of substantially limited, not to say what is a major life activity and what is not a major life activity. Now, ultimately, the duty is on employers to provide reasonable accommodations for their employees. Employers want to be compliant with the law. The last thing that employers want to do is run afoul of the law and have to litigate these issues in courts. And the only way employers can be compliant with the law is by a clear standard by which they can truly understand. Now, the Swallow Youth Court said that interacting with others is a matter of subjective determination, so much so that it may even possibly be unworkable as a standard. Interacting with others is necessarily context-based, and where a standard is context-based, so too will its application be. As the Jacques Court pointed out, interacting with others is distinct from major life activities such as seeing and hearing. For instance, we may look at someone and say objectively, this person is able to see or not see, or this person is 20% impaired in their ability to see. However, interacting with others is extremely context-based. What may constitute a successful interaction with another person will be different in one circumstance than another circumstance. It all depends on the actors that are communicating and the means by which they are communicating and the forum in which they are communicating in. Because interacting with others necessarily implies that two parties are involved and that there is this inherent social element to it, it's going to be a vague and confusing standard that employers will never truly be able to grasp. And this will lead us down what is a slippery slope inevitably.
Did people consider her someone who interacted with others at work? I mean, aside from your vagueness argument, in this particular case, is there any question that she didn't really interact with anybody at work?
Your Honor, there is a question as to whether or not she interacted at work, and we may say that she actually did. The record demonstrates this. The proper standard, as the plaintiff pointed out, to which we determine whether or not someone is substantially limited, is not the EEOC standard because it hasn't been adopted, but the Jacques standard, whereby someone is substantially limited if they are unable to initiate contact with or go among others at the most basic level. And under this test, Ms. Lambert did initiate contact and go among others at a most basic level. Ms. Lambert frequently met with her boss, Mr. Stonington, in his office to discuss deadlines and other work dealings. She also frequently communicated by email with her coworkers to discuss deadlines and to make sure that she understood her coworkers' author's intent and that she didn't edit that out in the process of her work.
Personal interaction. What evidence is there of personal interaction in this case, other than her going into her boss's office, standing at the back of the room with her head down and mumbling?
Your Honor, not just in the workplace, but Ms. Lambert has demonstrated an ability to interact outside in her own personal life. As you yourselves pointed out, she frequently would go to the pharmacy and talk to a pharmacist, or she would go to Starbucks and talk with her favorite employee there. As you pointed out, these aren't the most sterile environments. A pharmacy is going to be a place where someone with OCD would naturally be uncomfortable. But in fact, she stays longer than she has to, and she subjects herself to this hostile environment so that she may interact with a clerk behind the counter. Likewise at Starbucks, she doesn't just get her morning coffee and leaves. She stays there and talks with the barista behind the counter, and then she stays and works for an hour. In addition, she has had substantial personal communication, not only with her family, be it her mother, or also with friends online in an OCD support group. Now,
you know what really bothers me about this case? Just the big picture is here you have a person who apparently was very effective in completing her work, did excellent work with very minor accommodations involving her seating arrangements and her excuse from employee meetings. Now we have a new boss who comes in who's unwilling to make what I consider to be relatively minor interactions, and she's unemployed. Doesn't that bother you?
No, Your Honor. As you mentioned, she was able to do okay with some minor accommodations. However, just because she has a kind-hearted boss, that does not render her disabled. And in fact, the record demonstrates that Ms. Lambert has been able to interact with others when she is not benefiting from the ameliorative mitigating effects of medication or any such accommodations. If you look back in the record at her time in college when she maintained a 3.9 GPA and when she participated in extracurricular activities such as her college newspaper, she was completely able to interact with those circumstances. presumably in order to get a 3.9 GPA, you have to interact at some point, be it going to lecture or talking with professors during her office hours. Likewise, at the newspaper, she would have to communicate with the authors to make sure that she did not edit out their intent or what they wanted to say when she was proofreading. Likewise, in the journal.
I'd like to follow up on Judge Johnson's question. I'm not sure, by the way, that any of that is in the record, but we do know that in the record there is support for the situation that she had before there was a change in her supervisors. She was on the outer edges. She had a cubicle that was on the outer edges. She didn't interact with any of the other employees except somebody who went over and touched her hair and she went nuts. Other than that, she just communicated by email. There's a change in supervisors. That supervisor is unwilling to make any of these minor accommodations for her. And she's gone from a very productive employee, which the record is clear that that's what she was, to now that someone's unemployed. And your position is that it doesn't bother you.
No, Your Honor.
Explain that to me.
Ms. Lambert's reaction may be analogized to what the Swell Youth Court termed a reaction to the vicissitudes of life. In that it is expected that when people encounter everyday stressors or stressful situations that they have some sort of reaction. Take, for instance, somebody's reaction to death. Now, one person might react to the death of a member of their family very adversely, completely shutting down and being unable to do anything. However, another person might just be able to, I guess, shake it off and go about their daily life. Now, in that sense, Ms. Lambert's reaction to a change in the feng shui arrangement of the desk, any change made in order to promote efficiency in the workplace, or a change requiring her to attend staff meetings on a weekly basis, is likely a normal reaction that most people will have to these vicissitudes of life. It's expected that some people will react differently than others, as Ms. Lambert did.
Well, the changes were very minor, right? They were just to move her cubicle to the center and attend staff meetings.
Yes, Your Honor.
It seems to me that the majority of people that faced with that change would adopt to that change.
Not necessarily, Your
Why
Honor.
is that a stressor? In terms of some stressor that everyone would react, that the average person would be stressed for doing that or for facing that change. Well, you want to explain that? I'm not sure that falls.
Your Honor, Ms. Lambert's reaction falls within what we may term as the average range of people. Now, there's no one average person. Two people with diametrically opposed traits may both be considered average. So when we look at what most people do, we have to look at it among a broad range. Now, perhaps...
Okay, well, let me ask you this. Let's stop right there. Would a reasonable person who was told to move their cubicle to the center of the room and attend staff meetings or lose their job, would most reasonable people attend the staff meetings and move their cubicle?
And she did attend the staff meetings and move her cubicle.
And she couldn't, and then she complained that she couldn't continue to do it anymore, and she was told she would lose her job. Now, wouldn't the average person meet the new requirements established by her supervisor rather than lose her job?
Well, first of all, the new requirements are the most people's standard and not the average person. However, I contend that someone within the average range may possibly not react the same way as Ms. Lambert, may react the same way as Ms. Lambert.
So if we had 100 people, 100 average people faced with that same circumstance, there would be, what, 50, 60 of them that would decide to lose their job rather than attend a staff meeting or move their cubicle?
Your Honor, I cannot possibly speculate as to how many people out of 100 would react the same way Ms. Lambert did. However, we may say...
Well, you did. You said one average person would react that way. So I'm just saying, what about 100 average people? How many would react that way?
I do not know, Your Honor. However, it is possible that at least some people within this average range of 100 people would react that way. Now, Ms. Lambert's reactions in other situations may also be considered average, as most people do. In addition...
For a second, so you're about to be out of time, but I'd like you to articulate a standard you think would be reasonably objective that we can adopt that would support your position. I'm coming to the conclusion that we're gonna end up on a case-by-case basis. We're gonna litigate or accommodate, and courts are going to be full lawyers, full employment act. We need a standard for the 11th Circuit that would tell us where the substantial limitation rule ought to be. Give us one.
Well, Your Honor, I see that my time is up. May I briefly answer your question? Your Honor, you yourself pointed out that this is something that is going to have to be litigated on a case-by-case ad hoc basis. Interacting with others, because it is a context-based standard, is going to be indeterminate. And we may not necessarily know when someone is substantially limited in their ability to interact with others. However, even if we were to follow the Jacques standard, which was adopted by the Grizzle Court within the circuit already, which states that someone is only substantially limited if they are unable to initiate contact with and go among others, Ms. Lambert in this case is not substantially limited in her ability to go about others because she has demonstrated through the record that she's capable of performing at normal interactive levels. Thank you for your time.
Fine. 3 minutes to vote.
Your Honors, I have 2 points on rebuttal. First, the defense counsel incorrectly presumes that the appropriate test is the average person test and fails to recognize whether Ms. Lambert's impairments qualify as a disability under the most people test. And second, defendant incorrectly presumes that Congress only granted the EEOC the express authority to interpret the meaning of substantial limitation and not the meaning of the entire statute. Your Honors, to my first point, defense counsel contends that the average person, or some people out of 100, may not react with hives and feelings that they're going to die, and may not feel as though they're suffocating if their boss tells them to attend a staff meeting or puts their desk next to their coworkers. However, even under the previous standard, the 9th Circuit and the 2nd Circuit have both found that an employee who demonstrates consistent levels of isolation and hostility and an inability to communicate when necessary is sufficient to find that plaintiff substantially limited in their ability to interact with others. In these cases, however, in McAllen, while the plaintiff demonstrated feelings of lightheadedness and dizziness, Ms. Lambert's symptoms were much more severe. She felt as though she was going to die when she was around other people. And while the plaintiff in McAllen was able to go among his family, Ms. Lambert was not. She isolated herself from her only family member except for her mother. Your Honors, that in the ADA Amendments Act, Congress granted not just the EEOC, but this court, the authority to interpret the statute broadly, to be consistent with the purpose of the ADA. Congress expressed their clear intent to protect individuals like Ms. Lambert who suffer from such debilitating mental conditions. The ability to interact with others is an objective standard that fits within Congress's broad categorical definition of major life activities. This has been recognized by a variety of courts and therefore should be adopted by this court. And this court should follow the EEOC's express guidance, which identify interacting with others as a major life activity.
But what about extending the protections of the ADA to these types of circumstances and the burden that that's going to place on a whole bunch of other businesses that might be similarly situated?
Your Honor, interacting with others is an objective and workable standard, and it will not increase litigation because just like before the amendment, a plaintiff must still prove the substantial limitation requirement and able to recover under the statute. Therefore, to fulfill Congress's clear intent and the express purpose of the ADA, this court should find that Ms. Lambert is disabled under the statute.
Do you agree that it's going to be a case-by-case basis as to what a substantial limitation is, or do you have something to offer in the way of a standard that we might adopt for the 11th Circuit?
Your Honor, I see my time is up.
Yes.
The standard is already articulated by the EEOC and is appropriate under the current law. And the standard is a general comparison as compared to most people in the general population. The standard is to be, the level of limitation is to be determined when the symptoms are in the acute phase of their illness without regard to ameliorative general comparison to most people.
All right, thank you, counsel.
Thank you.
I thank both counsel for their arguments. The court is going to take the matter under submission. We'll be in recess, and we will come out to announce our decision in just a few minutes.
All right. You can be seated. There we go. The same justice is presiding. Okay.
All right, you can be seated. Okay, we're going to announce our decision on the case after a prayerful and deliberate consideration of the record and the facts. We have decided that that the plaintiff will prevail on the issue of whether interaction with others qualifies as a disability. We find that it does constitute a disability because it is a major life activity. On the second issue of whether the plaintiff, this particular plaintiff, is substantially limited in this major life activity. Of course, this is a factual issue that would be tried in front of a jury. But if we were the jury, I think the plaintiff has the better of it in this on the facts. You probably know that too. But we have some comments on your presentation, which, by the way, before I turn over to John and Judge Thompson, I just want to say that both of you were excellent. And I think I can underscore that this way by telling you that you were better than the vast majority of people that appear in front of me in the Court of Appeal. Wow. And that's just a fact. Your lawyers were as well prepared and as professional as both of you were in giving your presentations. John, any comments?
I have a couple of comments. One, I want to, I've said this before, I want to say it again, and it's directed to the writing professors that you all have. I'm assuming most of you are first years, family and supporters of the two people here in front of us. I'm constantly amazed, and I've done this a couple of times, constantly amazed that you're able to come up with major cases with issues for everybody. There's a lot in this that each of you could argue, and very fairly distributed in terms of the law and a lot of the facts. And I don't know whether you should be appreciating Professors Carey and Hartley dramatically. This is a wonderful program, and you are exposed to it, and it's part of what you do on a regular basis, and it results in what we all agree with, majorly good presentations by both of you. But kudos to the department and the school for getting such an interesting program. I expect you spent extraordinary amount of time on this. I could have spent another many, many hours trying to figure all this out. I'm going to let them talk more. They're real judges. I just pretend. I thought, again, really excellent. I thought both of you were very, very prepared. I thought you both had a lot of presence. You communicated that you felt strongly in the positions that you were advancing, and that is really important. When you're arguing to a judge, whether it's a trial judge like Judge Thompson, whether it's an appellate judge like Justice Aronson, really important that you're not just perceived as standing up, articulating something, but that you are arguing based on law and facts that you believe and that you want to advance for the benefit of your client. I think you both did a superior job on that. Also thought that you responded to questions really, really well. You both understand the materials very well. You understand the nuances of the cases. You were able to carefully avoid the ones that didn't support where you were going, and really well pick up on the ones that did support you and plug them into your argument. And basic points that you want articulated. I think both of you turned questions into, you responded to the questions, so you met the thrust of them, but you turned it into the arguments that you wanted to advance. I thought they were both terrific.
I would echo those sentiments, first starting with Justice Aronson. If there's majority of the litigants who showed up at my courtroom were as well prepared and poised as you two gentlemen are, I'd be a very happy trial judge. It's not always that way, but I thought overall both of you did an outstanding job. I understood the arguments; they were clearly articulated. Both of you had a really good manner, sort of a comfortable style at the podium. Both of you handled questions very well. I've seen lawyers that come to the courtroom, and I've watched arguments at the Court of Appeal. Lawyers come to the courtroom with a script, and they're bound and determined to stick to the script, even when in a trial court the witness says something that they didn't anticipate that creates an opening, and they don't delve into it. They stay with the script. Where at the Court of Appeal, even worse, you'll see these guys asking questions, and the lawyer just sticks to the script, doesn't even answer the questions, which is unhelpful. I mean, one of the main reasons for oral argument is to answer questions. So they're telling you what they're having trouble with. One of the questions, I think, Mr. Brown, I would have answered a little bit differently. The one about does it make you feel bad? Don't you feel? I think we discussed it a little bit back in the deliberation room. I probably would have answered that question by saying, well, of course, as a human being, I feel bad for her, but the law, and then get back to the law would be a better way to answer that question. But overall, just outstanding presentations, really clear arguments, excellent speaking skills, good demeanor, overall just outstanding on both sides in my view.
Yeah, of course, I agree with everyone's comments so far. You both were very good at segues. You know, the tension in oral argument is you have prepared remarks, and so you want to try to stay as close to those as possible because that's where you're comfortable with, and you've worked on those. But you know, unfortunately, this is a dynamic situation. You're going to get questions that may take you off course, and the whole idea is how are you going to transition naturally back to your prepared remarks? And sometimes that involves keeping the justice focused. I may have asked a question, I think, that was that jumbled a couple of different concepts, or we may have gotten ahead. I think we were discussing with you, Mr. Wampel, whether on the legal issue, whether this qualified as a disability, and then we started talking about the particular plaintiff, whether she was substantially impaired. And so we were kind of mixing two concepts there. I think you had a very good segue to get you back into your prepared remarks and get us focused on a particular issue rather than just sort of jumping all that. I thought that was a nice job. And you also, Mr. Brown, had very good segues back into your prepared remarks. I agree with Judge Thompson. You came off a little heartless when you said, I don't feel badly about her being dismissed. You know, the answer is, well, you know, it's you know, with some regret or some sympathy for anyone that you lose your job, but and then you bring it back into the issue that we have to decide, that is whether there's some sort of violation of law in discharging her.
I need to interrupt you, Your Honor. I'm very, very sorry. An emergency requires us to evacuate the building.
No issues.